Hi everyone, Sean Humphries here. Welcome to All Things Retirement. Well, in this installment, we are going to talk about powers of attorney and specifically clauses that should be in your power of attorney, and if they're not, could cause you, your power of attorney, and your family some problems. So I think you'll enjoy this installment. Now, why powers of attorney? Well, it's part of the overall estate plan, which would include wills, trusts, powers of attorney, and healthcare directives. You don't have a solid retirement plan if you haven't focused on the estate planning piece of retirement. You can do a great job on tax planning, investment planning, retirement cash flow planning, but if you haven't attended to the estate planning piece, it could cost you and your family money. So it's a really, really important area. Now, for this discussion, I was fortunate to have a conversation with Krista Clendenning with Traditional Law here in Winnipeg. Krista is a lawyer who specializes in estate planning, again, areas of trusts, wills, powers of attorney, and healthcare directives. So she provides some really great insights on what she says is a really important document. When you think about it, if you're an executor, that has a relatively defined commitment in terms of time if you need to step in that role. If you're a power of attorney, it could be a role that would last years. So the power of attorney document is a really important document to pay attention to. You don't run into your drugstore and get a templated document or form. You really should seek legal advice to get a document that's crafted to your particular circumstances. Now, if you're new to our channel, make sure you hit the subscribe button. We're posting content all the time on different aspects of retirement planning, the retirement journey, and wealth planning. So hit the subscribe button so you don't miss future content. Okay, let's go to the interview with Krista. Well, Krista, thanks so much for taking part in this discussion today on powers of attorney specifically, and looking forward to getting into this topic a little bit. And we've got actually a specific topic on powers of attorney, and that's on clauses. But before we get into that topic, how do you define power of attorney? What exactly is a power of attorney document or agreement?
Yeah, so power of attorney document is going to be a document that appoints someone to step into your shoes. So to take control of assets, property, finances in the case that you're unable to manage those things for yourself, or it could be like a delegation of an authority for that person to step in and assist with any of those things.
Okay. And I know that there are various kinds of power of attorney documents, and that can be a separate discussion for another video that we'll do together. But the most common form of power of attorney in your experience is what? Usually we kind of think of it, someone who's older, maybe has some frailties, maybe needs someone to represent them. Is that the most common scenario that you see, or are there more general scenarios than that?
Yeah, I think most people that I encounter doing estate planning are looking for a document that is going to be there and authorize someone to step in when they've lost capacity themselves. So typically what you're looking for in estate planning context is an enduring power of attorney, which means the authority you're giving to your attorney under the power of attorney document is going to be continuing and surviving after your loss of capacity. And that authority really will remain in effect from the point that you've lost capacity until the date of your death, unless you ever regain capacity during that period. So it's really potentially quite a long possible time that someone could be acting for you and managing all of your assets for your benefit.
Yeah, I think that's a really important point. I think often when people are approached to be powers of attorney, they often will, sometimes they'll say yes, it's kind of a goodwill gesture, but it's one of those roles that could go on for many, many years, right? It's not like being an executor where you could be a fairly defined period. Power of attorney could be extensive process over a long period of time.
Absolutely. And you're stepping into this in this fiduciary capacity. So you legal obligations once you start to act. You can't just step away. You usually have to be court removed, or something has to happen formally to allow you to step down. So if it's a role you're stepping into, you want to be prepared for it. And there's certain obligations that attorneys have that they're not always aware of either. An example that I will probably touch on today in this discussion is accounting and reporting. And often attorneys need to be reporting to someone and they're not always aware of that obligation.
Yeah, no, exactly. Well, you see, and you have seen a lot of power of attorney agreements over the years, not just the ones that you prepare, but obviously you've seen different situations. So if you had to come up with kind of a listing of clauses that you would recommend people have in their power of attorney agreement. I guess there'd be kind of a basic template or outline you'd see, but then customized clauses that probably should be in the agreement. That's what your lawyer would do for you. What in your experience do you see where you go, oh my goodness, I wish that clause was there, or specific areas you think people need to sort of pay attention to?
Yeah, so I think, any lawyer that's doing a power of attorney, we all have our standard form of power of attorney. So you're going to see some regular clauses in there every time, like authorizing banking or authorizing taking legal action on your behalf or something like that. So those are pretty standard. But in certain circumstances, there's different things that need to come into play. So one of the rules that an attorney has to follow is that they can only use your money for your benefit. So they can only take control of your assets and spend funds or use property for your benefit as the person that's the donor or the signer of that power of attorney. So one of the things that comes into play then is if you're a person who's financially supporting another family member, someone that you don't already have an inherent legal obligation to support. So generally spouses and underage children are already caught in that. But if you have an adult child with a disability, or if you're the financial support for a parent or another family member, you really actually need to have an authorization in your power of attorney to allow that attorney to continue the types of support that you're providing while you have capacity and control over your own finances. So that's one that I think should come up. It's just a discussion about, is there anyone in your world that you're supporting or that you would want to continue to support if you lost capacity? So that's one area.
Okay. What about now, let's say someone's been giving to a specific charity over the years. That's something that was really important to them. Or let's say grandma was helping with the grandkids with some educational costs or gifting every year. Does that come up into that clause as well, or is that separate?
Yeah, so that one I have more of like a gifting discussion. So if there's regular gifts or anything like that someone wants to continue to provide or authorize in the future, definitely looking at those things. So if that charity relies on that annual gift from you, and that's important that it's continued to you, even in the case you lose capacity, then build that into the power of attorney. And family gifting too. So, every time I do powers of attorney, I always make it very clear whether there's gifting or no gifting powers authorized. And to the extent you do have a gifting power, it's good to be very specific about that. Any attorney that's stepping in will want to know what the parameters are of these gifts. Is it open-ended education for all grandchildren, whether it's Harvard or UM, or is it, we want to make a contribution to RESPs every year of a certain amount or something. So it's really good to specify if you do have specific wishes, what you're looking for.
Okay, perfect. So those two are important clause areas. Anything else that you typically see?
Yeah, so other things that come up from time to time, if there's property. So another one might be a cottage property that parents are holding and the kids and grandkids are using in the summer. If the intention is that property is to remain with the parents and maybe there's a plan under the will about who's taking the cottage or some arrangement for succession with the larger family, it's good for the attorney to be aware of that as well. So even if it's just kind of an intention statement in a power of attorney, in cases where that attorney doesn't have a copy of your will or isn't in the loop on that plan, that can trigger them to know, okay, the plan here is this cottage has to remain an asset of this individual. Maybe you're authorizing, making really clear that the family can continue to use that cottage over that period of time, even if the person is incapacitated and can't get to the cottage themselves. Intention is that expenses are paid or taxes are paid or whatever the case may be for that cottage during that period. So that can be another one. And even a house too, like kids, you might have kids that are underage, but if something happened to you as even young parents, you would want them to be able to remain in the home until they're financially independent and maybe another family member would move in. So kind of thinking through those other possible future things where you want specific wishes for your property.
Now you you may be covering this off in your outline, but one area that comes to mind as well is when you talk about this long period of time being power of attorney potentially, plus you might be taking the person to medical appointments or doing various things over time for them or with them. What about compensation? So can powers of attorney be compensated? Does it have to be specifically outlined in the document? Would that be a clause area that you would talk to people about?
Absolutely. So always like to have a conversation about compensation and look at the family situation and
Yeah.
expectations are, maybe because, sometimes to the extent you have kids acting as attorneys, they may say, I'm absolutely willing to act and I wouldn't expect to be compensated. But if you want to open the door to allow that compensation, you should really have something contained in the document. And especially where you have people acting that aren't beneficiaries under your estate, ultimately. We don't know how long they'll be acting, even if they are a beneficiary. We don't know how many years they may be acting and the extent of the work they may be doing for you. It's good to at least have that option for them to take compensation.
Yeah.
And compensation generally is supposed to be court reviewed. But there are some functions you can build in terms of having an accounting review, maybe with family members that review that amount.
Yeah, like I think it's a really important area because probably one of the issues that you see all the time is that families don't talk through this stuff, or something happens, mom or dad, we need to use the power of attorney. Probably happens in estate planning as well. All of a sudden, the family is now looking at the document and going, "I had no idea that Jim across the street was listed as a power of attorney," or whatever it might be.
Mm-hmm.
And then they see compensation as part of that agreement for this power of attorney. And I'm sure there's situations where families are just really surprised, and it becomes a bit of a difficult, awkward situation for all involved. So probably the more the discussions around the table with families, probably the better.
Definitely. I always kind of coach families on those points, or clients on those points, that if something they're feeling uneasy about or they don't want to talk about with their family right now, that's almost more of a reason to do it. Because if it's going to be an issue when they're gone, the family doesn't have the opportunity to ask those questions and hear it from their parents or their family member directly that those were their intentions. So it's definitely a good idea to talk through those things so there aren't any surprises down the road.
Now, I know when we were talking, you mentioned something about the administration attached to power of attorney. Does that tie into how the documents are drafted, or is that more just an educational thing for people who are playing the role?
Yeah, so attorneys stepping into the role themselves and kind of what are the rules they're acting under there. Yeah, so I think, in my personal opinion, it's a good idea for any attorney who's stepping in to go get some legal advice.
Yeah.
Even just sit down for an hour or two, let a lawyer who's practices in this area, that understands the obligations of an attorney, sit down with you and explain them to you. And it's going to be different. It's not the same for every person that walks into your office. It depends on what the assets are that you're managing, the individual you're managing the assets for. It'll depend on the power of attorney document that you have, the jurisdiction that you're dealing with, and maybe even to a certain extent, the beneficiaries down the road that you may be reporting to eventually or under the will. So lots of different considerations that can kind of change that picture. I know you might have one, client that feels the role of an attorney is completely easy because they're acting for their spouse and there's no, everything's going to a charity at the end of the day. And there's not really anyone that's going to come hound them with questions later. But another person might have multiple kids and a blended family and corporations and all kinds of different things. And the picture is completely different and they need totally different advice. So definitely a recommendation to go get that advice when you do step in.
Yeah, no, exactly. So when it comes to that aspect, that's not necessarily a clause that gets built into the power of attorney. That's really just the conversation needs to be had with the lawyer to kind of go over those responsibilities. That's what you're talking about.
Yeah, not so much something that actually gets written into the document. One of the things I like to do is in my report letter to clients is advise them of that recommendation to have their attorney go get legal advice, because it can be paid from the person's funds. So if I'm stepping in as attorney for you, I can use your funds to pay that legal bill because it's absolutely appropriate for me to do a good job in that role.
Yes.
To understand it. So
exactly. So in my day-to-day life, we do a lot of work in the investment planning area. I may not be correct in saying this. So there's sort of that prudent man or prudent person world or term that we use.
Prudent investor rule.
Yeah. And so are powers of attorney generally pretty open-ended, and you just assume the power of attorney will make the right decisions around investments, as an example? Or do you see powers of attorney that actually put some structure around how that's to be done? Do you ever see that happen in those agreements?
You know what? I don't see much in terms of directions about investment. The general idea is when an attorney steps in for someone, they are really a trustee, and they're a fiduciary, and they've actually generally got to be very conservative in their investments.
Mm-hmm.
So I would say more so if you're a person that wanted to continue aggressive investment, even if you lost capacity, maybe then you'd be turning your mind to this. And
Okay.
I would want to take a hard look at it, even because I'm not sure, even as an attorney, if I was looking at that document and it says to aggressively invest, I'm still kind of balancing this duty to make sure there's long-term going to be funds here for beneficiaries and funds to support this individual. And I'm not getting into anything still too risky. So it would be, it's an interesting question I haven't really had come up.
Yeah, but that's a really good point. Like it's what's, I think, really pertinent in this discussion is you can imagine someone who has capacity right now. They're managing their finances. They've drafted the power of attorney document, but you already know, based on their finances, that they're trying to do two things with their financial planning. On the one hand, they're trying to have income security and live the lifestyle that they want to live. They have this gifting that's going on to charities or organizations, maybe family members. And then they might have some legacy aspirations where they want their estate to be maintained and preserved and eventually going to beneficiaries through trusts. So I can imagine that there's a kind of a difficult dance that powers of attorney have to walk, where your primary responsibility is to look after that individual. You have a fiduciary responsibility, and it's their needs first and foremost that you're looking after. And now these other aspects that were important to them before the power of attorney was activated, I'm not saying they take a back seat, but it's a balancing act, right? Between what they stated were important goals for them long-term, for their family, estate, and legacy, and what they need to have happen now for their needs. And so now all of a sudden the power of attorney is stepping into the breach to navigate that. But that's not their primary responsibility now. Their responsibility is to just look after the needs of that individual, correct?
Absolutely. Yeah. So stepping in as an attorney, your number one thing is looking after that individual. And that's really your focus. So if there is a cottage plan for succession under the will, but you need that cottage property sold in order to fund that person's care, then you've got to sell the cottage. That's the primary consideration when you're acting as an attorney. And then practically speaking, you may, if the person who's given you that power of attorney passes away, and now you're reporting to an executor, or you're stepping in now as executor and managing the estate, there may be a certain extent where you have to report about what you've done during that period. And then kind of, you might have questions coming in from other beneficiaries or kids or something like that. But your obligation is looking after that individual. And as long as you're following that path, you should, for the most part, be in the right.
Right. Wow. So there's lots to the role. And so the one takeaway, at least there's a lot of takeaways here, but one is obviously having a boilerplate power of attorney that you can pick up at the drugstore may not be the appropriate option, that you do need to have these documents crafted to your specific circumstances and what you want to see happen. And so that's obviously something that your lawyer would help you with in terms of crafting that document. So like you said, you can have a template, but that template doesn't contemplate all these different areas that you could be taking a look at.
Absolutely. Yeah. And another comes up, in Manitoba here, we have a clause that forces an attorney to give a report annually. And you can alter who receives that report by setting out a recipient of the accounting, they call it, in the document, the power of attorney document itself. And if you don't touch on that, if you don't provide directions to your attorney about who to make this report, depending on what your family structure is, if you don't have siblings or kids or a spouse alive and surviving and competent to receive the report, then it's going to go to the public guardian and trustee, which kind of brings that agency in, which already has a lot on their plate, just just even turning your mind to these things and having these discussions is really important. And sometimes there's a black sheep in the family that you don't want to be involved with your finances or even receive a report about what's going on. So tailoring that reporting clause is also very important in certain family dynamics too.
Okay, great point. Well, so there's lots to clauses as it relates to powers of attorney. It's not a straightforward area. So that's been very, very helpful, Krista. When it comes to the whole process in terms of the work that you do, what is your process around working with people around powers of attorney, estate planning, that kind of thing? Is it fairly straightforward? How would someone reach out to you if they wanted to get into a conversation about this area?
Yeah. So one thing I'll say about powers of attorney is people always seem to be focused on wills. I mean, will, the fancy thing, right? But a power of attorney is the thing that affects you the most because it's you while you're alive, incompetent, and someone stepping in to look after you. So between the will and the power of attorney, you're actually the one that's impacted with that document. So I think it's kind of underrated into the will, but it really should be given a harder look at for sure. For me, whenever I'm doing estate planning for clients, I tend to talk about wills, powers of attorney, and healthcare directives. And healthcare directives are really that flip side to the power of attorney. So dealing with the medical piece, whereas power of attorney is the financial piece. And all three of those documents are really the core for any estate plan. You've got to have those three. And then depending on your circumstance, there might be other things you need too. But basically any person, single, married, kids, blended family, whatever it is, you pretty much need those three documents.
Yeah, it's interesting. I'll have conversations with people sometimes and they in their mind think that their executor and power of attorney are the same people. I'm not sure whether you come across that, right? And you've really underscored the fact that these are very different documents. Not only is it you're alive still, but the role is can be much different and long-term. And this fiduciary role is pretty heavy stuff. It's a big responsibility.
Absolutely. Yeah.
Thanks so much for doing this today.
Perfect. Thanks for having me.
You take care.
Thank you.
Well, I hope you enjoyed that conversation. Krista had some great insights on powers of attorney and specifically clauses that you should consider. This is not a document that you buy from your drugstore. It's something that you should have drafted by your lawyer and customized to your particular family circumstances and concerns. So if you want more information about estate planning, how to get your will updated, powers of attorney, healthcare directives, trusts, be sure to reach out to Krista. Her contact information can be found in the show notes to this video. As well, in the retirement planning area, if you're beginning to think about retirement or just want to know that your retirement plan is tracking in the right direction, click the link to our website. You can find out how you can get a complimentary retirement plan and review. As well, we have additional retirement education resources that you can grab free of charge as well. Anyway, wishing you all the best in your retirement and wealth planning journey. You take care.